Today on Legal Talk, we are discussing possible changes to South Africa's cannabis law in 2024. And joining us from Hahn and Hahn Attorneys is Associate Attorney Isabella Mazzone. Isabella, nice to chat to you again. Hope you're well.
I'm well, thank you. How are you, Ian?
Great, thank you. Nice to chat to you. Listen, the last time we spoke about cannabis, we discussed the publishing of the draft of the Cannabis for Private Purposes Bill, which is yet to become an act of Parliament and is thus still in the works. What is the 2024 update?
So, separate to the issue of the pending bill, the Minister of Health, on the recommendation of SAHPRA, published a proposed change to the schedules of the Medicines and Related Substances Act, and they published it on the 15th of January. So this amendment is super important to take note of because as it currently stands, tetrahydrocannabinol, otherwise known as THC, which everybody knows is the happy part of cannabis, is a Schedule 6 medicine. And Schedule 6 currently includes THC with the following three exceptions, which is in raw plant material and processed products intended for industrial purposes and not for human or animal ingestion, containing 0.2% or less of THC. Secondly, processed products made from cannabis containing 0.001% or less of THC, or raw plant material cultivated, possessed, and consumed by an adult in private for personal consumption. So those are the current three exceptions in the schedules. And the proposed amendment will amend these circumstances where THC is excluded from Schedule 6. And if the amendment is published as final, THC will be excluded from Schedule 6 when it is in a raw cannabis plant material cultivated and possessed in accordance with a permit issued in terms of the Plant Improvement Act, and processed products manufactured from such material intended for agricultural or industrial purposes, including the manufacture of consumer items or products which have no pharmacological action or medicinal purpose. So that's a very, very, very specific exclusion. Or raw cannabis plant material cultivated, possessed, and consumed by an adult in private for personal consumption. So that one remains as is. So those are that is the amendment that they're trying to push forward.
Okay, Isabella, what are the legal implications if this draft amendment is now published into law?
Well, the key difference between the current situation and if the amendment goes through is that the responsibility for setting a limit on the THC content in low THC cannabis, which we would also refer to as hemp, intended for agricultural or industrial purposes, will now lie, instead of with the Minister of Health, now with the Minister of Agriculture, Land Reform and Rural Development in terms of the Plant Improvement Act. Whereas previously, the 0.2% was obviously stipulated in the schedule itself. The other difference is that the previous limit on the THC content of processed products was removed in this draft amendment. The exception for adult use remains in place, like I said, which would need to be read with the Cannabis for Private Purposes Act once it is actually passed. The bill was passed by the National Assembly in November 2023, and as the process goes, it was then referred to the National Council of Provinces, the NCOP. And when the NCOP Select Committee on Security and Justice was briefed in November 2023, they made the following decision. They said that the Cannabis for Private Purposes Bill was drafted to govern cannabis for private use by adults in private. The bill was in line with the Constitutional Court judgment and was in line with the Constitution. The Select Committee would advertise the bill for public comment and then further deliberate on the public inputs. So that public comment process has yet to be initiated. However, as this is a Section 75 bill, the role of the NCOP is very limited. And an ordinary bill that does not affect the provinces can only be introduced in the National Assembly. And once it has passed there, it must be sent to the NCOP. In this case, delegates in the NCOP vote individually, and the bill must then be passed by a majority of delegates present. If they reject the bill or propose its own amendments, the bill is then returned back to the National Assembly. So this is the normal process. which will then either pass the bill with or without taking the NCOP's amendments into consideration. The NCOP's role in bills that do not affect the provinces is therefore very limited, and it can delay a Section 75 bill, but it actually cannot prevent it from being passed. The exclusions have the effect that substances and mixtures falling within the above exceptions would not be scheduled substances, rather regulated in terms of the MRS Act. Accordingly, products, including products for human consumption, will not fall within the scope of Schedule 6 if they have no pharmacological action or medicinal purpose, that being the key word there. In contrast to the current regulatory regime, which excludes products from Schedule 6 based on a set percentage of THC. The current situation with the issue of the complementary medicines being regulated separately from the MRS Act is still pending, and we're still awaiting amendments in that respect. But these proposed changes seem to be another move towards decriminalizing the use of cannabis in South Africa. However, there are other parts of our own South African laws which don't actually align with these amendments. For example, the Drugs and Drug Trafficking Control Act is still in place, and the relevant schedules still need to be made to ensure that cannabis use is above board and actually lawful. Currently, the Act still stipulates that no person shall use or have in his possession any dangerous dependence-producing substance or any undesirable dependence-producing substance. And in their actual schedules, they specify that an undesirable dependence-producing substance includes cannabis, the whole plant or any portion thereof. There's a lot of amendments of other pieces of law that needs to take place before there's any real movement in the decriminalization.
Okay, and then finally, when is the due date for comments?
So comments have been requested to be submitted within 2 months from the date of publication. So that means they must be submitted by the 14th of March of this year. But by the way, this is quite an unusual step, rather, as when the schedules to the Medicines Act are actually changed, they're not usually published for comment. It's normally an immediate implementation process. So this is quite interesting that they've done this. They really actually want the public to comment on this amendment.
That is very interesting. And just in case I didn't mention it, this week's edition of Legal Talk is called It's High Time.
You've been waiting to say that one.
Yeah, absolutely. Isabella, it's always great talking to you. Thank you so much for your input, and wishing you a wonderful rest of your week.
No problem, Ian. Thank you so much for having me again.
Are you or your business in trouble and struggling to find a solution? Call Hahn & Hahn Attorneys as we assist clients in finding solutions. We specialize in consumer and food law, commercial and construction law, forensic investigations and administrative law. Visit hahnlaw.co.za. That's HAHN. We assist clients nationwide. Hahn & Hahn Attorneys, because we care. Don't miss Legal Talk with Hahn & Hahn Attorneys, Wednesday mornings at 10 on eRadio.